Okay, assalamu alaikum. This is the second lecture on bankruptcy. Bankruptcy we have in general, we have liquidation and reorganization. Some points we have to look at and discuss once we talk about liquidation and reorganization. You know that we had last time we spoke about liquidation, in which we have insolvency. We have to end the life of the bankrupt in the market. You have something behind you, something you should not go back to, a life, financial life, business life, which is ended, and you have to start a new life. It's a fresh start. And in liquidation, as you can see, that we have the non-exempted assets and the exempted assets. The non-exempted assets has to be taken from the debtor. We have exempted and non-exempted assets. We have to keep the exempted assets, the money, the house, everything has to be here for the need of the debtor and his family. We have to keep. We have to leave. Anything extra we have to take away, which was called non-exempted assets. We have to take it away, we have to sell, and we have to divide the money between creditors. So we have the debtors, have to focus on we have the non-exempted assets. So in bankruptcy liquidation, tasfiyah, we end the life, then you will not be able to work in business. Take notes of these points. Number one, your business will be closed down. No business anymore. You cannot be working in business. It has to be closed down. Number two, your assets, including the cash, the car, the house, the land, everything you have which is non-exempted, which is non-protected, non-exempted assets, something extra money you have, extra money, more than you need for your basic life, we have to take it away and then we have to sell. We take the money and then we divide it between creditors. And number three is you have to pay the money you have. What money you have, what cash, what extra money you have will be taken away and will be divided between creditors. In this case, creditors might not get what they want exactly. You might pay the money you have, but if you don't have enough money to pay as a debtor, as a bankrupt, if you don't have enough money to pay all your debts, then no one can ask you in the future to pay anything. You have to have freedom here. You have to have which is called discharge, which is equal to freedom. You can't be free. You should not be anything. No one can ask you for nothing in the future. Once you have to this stage, come to this stage of discharge, you will be free. You will not be asked to be anything else. This stage, it takes sometimes 1 year or 2 years. We'll look at that in the UK and the USA, how long it takes. From the time we have the bankruptcy order, once we have this decision is made by the judge, bankruptcy order, it's a judgment, it's a final decision, then you become bankrupt. Once you become a bankrupt, it's a completely different story. It's not like debtor. Debtor is not equal bankrupt. It's muflis. Still, you might take more steps to be a bankrupt. You can be a debtor, but you can pay the debts. Sometimes you can be in debt, but you can pay. And you aren't due to pay the money, and you pay them on time. In this situation here, then no one can ask for your bankruptcy. You can stay in your business. But once you are stopped here, you cannot pay the money anymore. Now, you cannot take any more steps to pay your debts, then we can ask for your bankruptcy. So the assets are sold off to satisfy creditors. Those creditors here with timely and valid claims. We have timely and valid claims. Now, imagine that you have as a debtor having 10 creditors. All of them have to join with the same bankruptcy petition. You have an announcement in a newspaper. This announcement in the newspaper says that this debtor is about to be a bankrupt, and we have a hearing in the court. Then Annie give a notice, a time, specific time for all the creditors to join in this case. Once they have a bankruptcy order made by the judge, no one can ask the debtor for anything in the future. Then all creditors will timely filed on time. If you miss this date, if a decision was made and you did not join those creditors, you would lose your money. Even if you have, like, let's say that I was in debt for £500,000 and all what I have today is £150,000. Then the court would take the money and divide it between 9 creditors. But still one did not join. He was lazy, he didn't know, he did not follow up. That's his own problem. We don't care. If he did not join on time, then he cannot come later and say, well, I forgot. Or I did not ask for my money, I want my money. I want some portion of that money. No. The £150,000 will be divided between the 9 creditors. And that one, number 10, he did not join on time, then he would lose. He did not get nothing. And those claims have to be valid, not disputed. Like, I was in debt for 10 people, now we have no dispute about this. Then the money have to be divided on a system which is called pro rata, by percentage. The money, the assets, those non-exempted assets of the debtor which have been collected can be sold off. We take the cash and we divide it between creditors on a system which is called pro rata, percentage. Because it's not fair that, like, you have one creditor with £50,000 and one creditor with £10,000 getting the same amount of money. No. It's based on how much money you would have, how much money you lend that person, the debtor. Then the money can be divided on that. And we have a different thing we have to mention here. Even once we divide the money, we divide the cash between the creditors, we have priorities between secured and unsecured here. Secured and, look at this in the exam, this is so important. We have 2 types of creditors. One of them is called secured and the second is unsecured. Most creditors, most of them are unsecured, which we call them general creditors, unsecured. Then you don't have something guaranteed. Those secured creditors, they have guarantees. في ضمانات. They have guarantees. It might be a car, it might be a house, it might be cash. They have some guarantees. But then what we have to do in this, we have the cash. What can we do with that? If we have a priority, who can we pay first? Secured. And what money left behind can be divided between unsecured creditors. So first we have to pay secured. The money left after that, if we have like 2 out of the 10 creditors are secured, we pay them all the money because they have guarantees. في ضمانات. And then what has been left behind, the rest of the money, can be divided between unsecured creditors. That's a priority system. That's all in liquidation, but it's not the same if we have reorganization. In the second case, as you can see here, in the second case, we have reorganization. This is called in the UK voluntary. Voluntary arrangement between the 2 sides. We'll look at that later on. But then reorganization, bankruptcy, it's completely opposite to what we have in liquidation. In liquidation, we liquidate. We end the business. But here, no. You can carry on. Stay on. You can do your own business. Keep it. Enjoy your business. And in liquidation, we take your assets. We take your money everything. In this case here, no, you have to retain. You can keep your assets. Retain to keep your assets. And in this situation of reorganization, we have to pay the full amount of the creditors. In liquidation, if I was in debt, I would pay only what I have. In liquidation, if I have only 10% of what I'm supposed to pay, then I would pay the 10%. And the 90%, no one can ask me. Once I have a discharge, in the future, no one can ask me nothing, even if I become a multimillionaire. Once we have a discharge, it means freedom, relief, a new life. Can forget about the past. Leave it. Now, in this situation, as you can see, that we can keep the assets, we can keep the business, and we have to pay the full amount of money. But in this case, we have a new time notice. We have to have the money to satisfy creditors' claim. It's kind of هو بسموه إعادة الجدولة. And if I was in debt and I have to pay £500,000 today, but I don't have the money, then you might give me notice, time. This would be over 2 years, 5 years, 3 years. It depends on the amount of money. Then within that time, I will be able to pay the whole amount of money. Now, some people would like to have liquidation. Others don't like to have liquidation. Because in liquidation, in reorganization here, we survive. Survive what? Insolvency. We don't have liquidation here. In reorganization, we survive insolvency. We survive liquidation. We can stay in our business. We can keep going on. We can here, and we can be protected. We can be protected from any claims. The only way you can get your money if you have reorganization is it's the court. This is a new channel. It's the only way in which you can be. Because here we have a plan. And this plan, we have a proposal. In this proposal, I can, as a debtor, I was in debt of £500,000. I can provide a proposal saying, I can pay you the money, but I would need 2 years. But I have to specify in the plan how much money I can pay every month. And I can specify how can I get the money. And I would state some guarantees, because if I cannot pay the money, they would take it from the guarantees. So this stage here, in this way, reorganization, it's not easy to happen. Quite often people have liquidation, they don't have reorganization. Reorganization, we have guarantees, في ضمانات. We have guarantees, we have money to be paid, we have somebody to stay in business, so we have to make sure that everything I have stated in the plan is correct. And I would have the guarantees, and I would have the sponsors. So if I don't pay, my sponsor, what sponsor? الضامن, he would be instead of me. Now, once I do all of this, no one can ask me. I will be protected. Okay, I gave a promise, a pledge, what? That I will pay you. Okay, I will pay you. Then you will not ask me again. You have to wait your turn until you get the money. And no one else can do here. I can be. Debtor is protected. Protected from what? Most non-bankruptcy legal action. Creditors cannot pursue most types of lawsuits. Well, everything is frozen. I would have to pay you, but within the plan, with the plan. Now, some people think bankruptcy, liquidation is better than this. Because in liquidation, if I was in debt and I have bankruptcy, I was in debt and I have bankruptcy, and then I would have discharge, would have freedom. I don't have to pay. I don't have to think. Like, imagine yourself. Yes, but imagine yourself. How is it good or bad? You, as a debtor in the market, imagine that today you are in debt for £500,000 or £2 million, because we are talking about companies and business people who invest too much money. You are in debt for £1 or £2 million, and then you have 15 creditors, and every day you are in court to respond to them. Like, every day is asking you to pay the money, and you cannot pay the money. You might be in a prison. What shall you do? and suddenly you find a solution. It's a magic solution. It's a magic solution. Solution says here that suddenly you can be free. No one can ask you for nothing. That's a liquidation. Liquidation. That we have the first time, not the second, the first time. You can be free. No one can ask you. For some people, liquidation is a solution. It's good. For some people, it's not. It's a bad thing, because liquidation, it means an execution, i'dam. Execution for the person, whether going to be a natural person or fictitious person, company or human being. It's execution because this is the end of the life. That's it. Done. Close the business. Take your money. You will be frozen. Stop. You cannot work anymore in the market. Even if you have a discharge, FIFA, and you have in the future, you come back to business, because you might come back to business. If you would like to come back to business in the future, you can, with the permission of the court. The same court will give you permission to come back to business. But I don't think that anyone in the market would trust you. Someone like, I was in debt for the amount of money, and all of you are creditors, and I came back after 10 years to work on the market. Are you going to trust me? I did not pay the debts. I did not pay. I was free. By the way, in Islam, there is no bankruptcy. No bankruptcy. Because in Islam, if you are in debt, you have to pay the debts. Even after you pass away, after you die, your inheritance would have to be there. Because everything would be forgiven except of the debts. But this is man-made law. Even in Palestine today, we have the same situation, man-made law. We have bankruptcy, and we have some cases in Gaza here in which we have some people applied for bankruptcy because it was the only solution for them. They could not pay the debts. But if they want in the future to pay their creditors, even if they have the freedom, it's up to them. But no one can force a debtor who becomes a bankrupt. A debtor becomes bankrupt. No one can force him to be anything. Free, خلاص. ولا حد بسأله. That's a new life. Imagine, this is not something acceptable in our society, isn't it? What can you do? Like if you give somebody 10,000 dinars, 20,000 dinars, and they say, well, yeah. You might take drastic actions. In society here, which people don't believe in bankruptcy, because they spend their life making money, and suddenly somebody take your money and get away with that. But this system of bankruptcy is made for honest debtors. Honest, you might lose, you might win. Say, well, somebody is in debt, and he or she has no money. What can we do? Are you going to stay for the rest of his life in the prison? This will not make any difference to you. And even does not make any difference to anyone. If he stays in prison or at home or free, he will not pay. He will not pay anyway, because he does not get the money. But if he or she is free, they might work and they might pay back in the future. No, with bankruptcy, no. If you announce bankruptcy, خلاص, you can't ask. You can't ask nothing. The punishment is stop working in the market. You're gonna see later on. We have some disadvantage of bankrupt. What would happen to this person? We have many points. What would happen to you? Usually in the society, if you become a bankrupt, it's not an easy. It's a stigma, like wasma, against that person. Sometimes people like this do not even get out in the street to talk to people because they feel afraid. They lost their dignity. They lost their honesty. They can't talk to people anymore. There's something I want to mention before talking about bankruptcy in the States. We have something called bankruptcy fraud. We have a number of people who are applying for bankruptcy. In fact, they are not bankrupted. If you look in Google, if you open Google and search, you find thousands of companies bankrupted every year. Thousands in Europe. Tens of thousands even of companies. You find many individuals, and I know I've seen many examples like this when I was in the UK, people applying for bankruptcy, despite the fact some of them were cheating, deceiving. They can hide the money somewhere and say, well, we lost. Now, how can we deal with such case? There is no bankruptcy. If we make sure that this person was deceiving the court and he has the money, he was hiding it, and he was not following the legal system, then there is no bankruptcy. He will not be forgiven. No. He will not be discharged. Then we have to follow him until we get the money. The problem is it's not easy to prove it. Because there are some smart people can get away with the money. They know some people make the business, open the companies, they get some loans from the banks, millions of pounds, millions, and they open the business for 1 or 2 years and then they apply for bankruptcy. Like that. They hide the money of somebody else and they have nothing in their names. Nothing. And they pretend to be lost. Then, Mr. Fido, they get the money. They don't care about it. They don't care about reputation. So those are type of people. We have them. We have such people. But if we can prove that this person was not honest, the bankrupt was not honest, then he will not get it. Will not be forgiven. He will not be discharged. He should be. Now we have to move to the bankruptcy in the United States. All a few slides. United States, like other countries, they have their own law, which is called bankruptcy. You know that in the States we have 52 states. Each state has its own law. Each state has its own lawmakers. صانعي القانون. But sometimes we have some important issues in which we have to deal with them by the Congress here on the federal jurisdictions. The most important issues at all which concerning the whole United States can be enacted by the Congress at federal level, non-federal, which is the United States level in general, one of which is bankruptcy. Bankruptcy in the United States is a matter placed under federal jurisdiction. It's only one law for all states. Not each state. Like if you want to have civil law, commercial law, tax, you can have things done in each state. But when it comes to bankruptcy, even it's part of commercial law, but bankruptcy is organized under the federal jurisdiction. Why do you think this? Why do you think that bankruptcy is enacted, is made at the federal level?
Because I think at the wide perception, bankruptcy this matter affects the economy
Yes.
states. And bankrupted people can deceive the whole states by manipulating the laws and going from state to state. So there has to be one law to control them.
Yes. What else? That was good. Think about it. Hánي. Bankruptcy is something affect the whole society. We're not talking about small companies. We are talking about big companies, corporations. Some of them invest billions, not billions of dollars. Some of those companies employ tens of thousands of people. Imagine one company having 300,000 employees. What would happen to this company if it's bankrupted? What would happen to the state economy? One company have 50,000 employees. 50. Imagine that 50,000 employees today sitting at home have no income. What would happen in one state or two states? This would affect the United States economy. Then the United States government would have to pay those people to survive. They would have to feed them, would have to accommodate them, and this would cost a hell of money. Now, economy is based on a system made by the states. One of the main elements in economic system in the whole state is bankruptcy law. Bankruptcy law has to be made at the highest level in which we have to protect the society. We don't want any company just at any time, oh come on, we're just applying for bankruptcy. No. You have to be responsible for this. We're making here tough decisions. We make the procedures, tighter procedures. So it's so difficult for anyone to apply for bankruptcy. It's really difficult. I mean, it's difficult from the beginning. If you want to have a business which you can invest a hell of money, like millions or billions of dollars, then from the beginning, it's not easy. And we've said before that, we said, if you want to open limited company or limited liability company or partnership, that's easy. But if you would like to establish public corporation, you need more procedures, investment, inspection. That's because you invest too much money in which the state can be affected. Now the Congress, look at this. Imagine that each one of you is a state, 52 states. The Congress enact uniform اللي هو مقصود به القانون كله. Uniform law, one at the same time, the subject of bankruptcy throughout the United States, in all the United States. But okay, we have today the bankruptcy law, which is made at the Congress level, but we have to apply it in each state, isn't it? What do you think? Each state, they have the same situation? It's not. Each state have its own law, its own system, its own economic way. Some of them rich, some of them poor, some of them have too much investment, some of them not. Then we take the bankruptcy law in each state. In each state, we can amend, not amend like changing, no. Can amend to be suitable for each state, but at the same time not to affect the bankruptcy law. Here, like its implementation. However, implementation. Anyone can read? I want to read it.
Its implementation, however, is found in tax law. The different
statutes are
incorporated within the bankruptcy code and amplified by state.
As you said, sometimes we can amplify, we can amend, we can incorporate some elements within bankruptcy law to be suitable and appropriate for each state. Now we do have sometimes some exceptions. Not with changing the law, but we have some exception in which we can use the bankruptcy law, but we can use our needs in each society, in each state. Because if you look in the north and the south in the states, they're not the same level. In the north, they are rich. In the south, they are poor. In some states, you have too much tax to be paid. Other states, you don't have that much tax because you want to encourage people to invest money. Now, in the states, you have bankruptcy. Bankruptcy law is organized by two chapters, mainly. Chapter 7 and Chapter 13. Chapter 7 is liquidation. Again, there's nothing new here. Nothing new. Chapter 7 is liquidation. And Chapter 13 is reorganization. Do we have any presentation today? Where are they? 1, 2, okay. Liquidation and reorganization. Chapter 7, as you can see, the same thing what we just seen before. We have non-exempted property, non-exempted assets have to be taken away from the bankrupt, from the debtor. We can sell them. We can divide the money between secured and unsecured creditors. Now, why should we take the money from you as a debtor? Why should we sell and we divide? Because in return, you have to have the freedom, discharge. In exchange, the debtor is entitled to a discharge. بمعنى الإعفاء. That's it. إعفاء, the freedom. We have the freedom. We have the discharge for that person. What do you think? There's something here we have to keep in our minds. Someone was in debt. We've taken all what he has. We left some money, a little amount of money for him and his family to survive. We give you accommodation, some food, some little money for you and for your family to be able to live a decent life. And that's what we call exempted. We take the non-exempted, which is extra money, we take it and we sell. And then after that we can forgive that person. It's the discharge, the freedom. But we do have some exceptions. Listen to that carefully. We do have some exceptions. We forgive people like those bankrupt. We're not going to ask them in the future for nothing, but we do sometimes. We do have some exceptions in which you would have to pay the money even if it takes 50 years, even if it takes the end of your life. As a debtor, you would have to pay the money. We have two examples, like for example here, a discharge will not be applicable in those two cases. Can you read it?
Certain types of incorporates behavior.
If he was guilty, what guilty? مذنب. Certain type of inappropriate behavior. Like for example, he was concealing information. What concealing? خف information. Was concealing information, or financial condition here, even to financial condition relating, mainly because if you hide something, if you hide money, if you hide bank accounts, bank statements, if you keep your accounts away from the trustee, then in all situations here, you will not be discharged. We have to follow that person again and again until he pays. Number two,
Except that some debts, for example, spousal support, some taxes will not be discharged even though the debtor is generally discharged from his or her debt.
Okay, even if you are discharged, there are some debts you will not be. Like some of those are connected with the public policy, public interest, like the tax. Tax is not personal debt, isn't it? It's not personal. Tax is for the state. Then you have to pay it for the government. It's not for personal debt. In addition to spousal support, like the wife, his wife, and he's supposed to be, because how can she live? How can she survive? His children. That's what we call spousal support. The money has to be paid because we are talking here about life, the concern of life, public interest. In such cases, these are two examples. I mean, the judge can find ways to look at such situation in which sometimes, at some points, we will not be able to discharge the bankrupt in some cases.
Some taxes like exemptions and deductions because it's excluded income, right?
What do you mean by that?
ما بتنعرفها إنه some taxes this doesn't have discharge about it because it's later before it's exempted, صح?
It's not exempted, the tax. It's not.
في عليها exemptions and deductions.
Fee reduction sometimes it's not. I mean, the tax was not personal right. It was the state. It was for the state, and it's supposed to be for the state. And even
related to the state, not to individual.
the tax, we pay the tax for the state or not? Tax office. We pay the tax for the tax office, and like people who did not pay the tax for a while of time, and then we discover this, they have to pay it. They would have to pay it. Somebody asked me a question last time, asking if the debtor has nothing at all, what can we do? He's got nothing. It's not about homeless. It's about like he has no money to pay at all. Like if I was in debt, I have only 10% or 15% or 20 or 50. But sometimes you find somebody has nothing. All what he has only exempted property, like clothes, household goods, old car, things like this, exempted. Are we going to take them away from him, or are we going to keep them?
The court gives something to this person that make him survive in this.
It's not leave. He's got nothing except for the exempted property.
Cannot take it.
We cannot take it.
Of course.
We cannot take it. Of course. Are you sure?
Yes.
Okay. Of course. So even if it was your money, concerning you, are you going to forgive that person? No, I don't think so.
You will not survive.
Okay. Now, in the United States, it says, now we have something called the relief. It means the same thing. It's a discharge. How often somebody can apply for relief? How often somebody can apply for bankruptcy? Today we have bankruptcy. And can we apply again in the future? Yes. Now, if we have bankruptcy today and we have a discharge FIFA, you can apply for permission from the same court in the future after a few years to come back to business. If you come back to business after a few years, then you're faced with the same situation. Can you apply for bankruptcy? Yes. In the United States, it says that you can apply for bankruptcy every 8 years. At least you have to have between the first and the second bankruptcy 8 years. Here, data seeking. Can you read it? Yes.
It is available only once in any 8-year period. Debtors seeking to heirs, all debts will have to wait 8 years from their last bankruptcy before they can file again.
Good. Again, going to the same point we have just talked about, secured and unsecured. You have to focus sometimes. In some cases, not in most cases, in some cases only, you find some secured creditors, secured. Now, those secured creditors, they have guarantees. Then they have to take the money first, even if there was nothing left behind. All what you have, Haneen, you have £50,000 and you're in debt and you have 5 creditors. And I'm the only one secured creditor and I have guarantees and my money was £60,000. I can take the 50 and nothing can be left behind for the rest of the creditors. Because of what? Can you read it? Dalia.
Generally, the rights of secured creditors to their
collateral ضمانات
continues even though their debt is discharged. Example, absent some arrangement by a debtor to surrender a car or reaffirm a debt. The creditor with a security interest in the debtor's car may process the car even if the debt to the creditor is discharged.
We have the example here in which the car was the guarantee. The car itself, it might be the house, might be a piece of land, like I give you £20,000, but I can't take guarantee, which is your car. Keep it with you, but the guarantee is, the collateral is the car. If you become a bankrupt and the trustee have taken your car, I can follow it. I can take it from anyone. The secured creditor can take my right from the hand of anyone. Because this is my right. The car was mine. This car instead of my money. Then in this situation here, these secured creditors can take their money before anyone else. In chapter 13, even in addition to that, secured creditors, can you see that? May be entitled to greater payments than unsecured. They can get their money, all of their money, and unsecured can get nothing, can get little amount of money. In chapter 13, it's talking about reorganization, not liquidation, it's reorganization. Talking about retaining the ownership, possession of all the assets. Same thing, there is nothing new here. It's talking about the plan, repayment, which I mentioned before. We have to have a plan. You cannot apply for reorganization without a plan. And this plan has to be done between 2 people. Meaning, number 1 is the debtor. He can sit down with somebody which is called the trustee. It can be a lawyer, it can be an accountant. We call him insolvency practitioner. We'll look at them later on. Insolvency practitioner. This is a specialist person, can sit down with the debtor, make a calculation, look at the account and the money and what you have in the market and all the assets you have and how much money you can make, you can pay, and how long time it would take to pay the whole amount of money. And then all of this would be in one file with the attachment. The attachment would be the documents can approve what you have, and the guarantees and the sponsors' names, and everything will be submitted to the court and to the creditors. In this case, I think we'll look at this later on. In the UK, you have to have the approval of 2/3 to 10, not half. At least you have, for this plan, has to be approved by 2/3 of the creditors. That's an important point. I make a plan. I have to convince the creditors that I will have to pay them. If they don't accept, it's fine. But if two-thirds of them accept such a plan, then this plan will be submitted to the court to finalize it. Even if not getting the acceptance of all creditors, that's fine. We have to have the majority accepting such a plan. But the minority, 1/3, we don't care about them anymore. We look at the majority of the creditors. I mean the majority of the creditors who have the majority of the money in debt. We look at this anyway in details later on. The creditors who have the majority of the money. See that I was in debt for £600,000. £600,000. I would satisfy the creditors who have at least £400,000, 2/3 of the amount of the money, and the rest of the creditors were not much concerned about them. They have to accept such deal. And we can summarize what we have by saying that we have liquidation and rehabilitation. Again, just see that we have the collect, the non-exempted property. As I said before, not much new here. But next time we have to look at bankruptcy in the UK, in which we have too much information. We have to look in details. We have liquidation and we have rehabilitation. Rehabilitation, we mean the reorganization, the same thing. In which here we have the debtor to allow him to use a future earning to pay off. I can get the money I can get as my income, as my profit, and I can be my creditors to stay in business. I can stay in business. After bankruptcy proceeding is filed, what would happen? There's something new here. After we submit the bankruptcy file or the petition, things can happen like here. What we're supposed to do like here, we have something on the creditors and something on the debtor. If you have a question like this, you might have a question like this, saying that after we submit the bankruptcy petition, there's some responsibilities on the debtor and other responsibilities on the creditors. One of which is, can you?
Creditors may not seek to collect their debts outside of the proceeding.
The only way for creditors to collect the money is the procedures or the bankruptcy. We have only, as I said, one way. That's the only way. Creditors cannot ask for the money. You cannot go unofficially. You cannot go to knock at the door. You cannot go to another court. You cannot go for arbitration. The only way is procedures of bankruptcy.
Creditors is not allowed to transfer property that has been declared part of the state subject to procedures.
At the same time, debtors will not be able to transfer. Like, let's say today we announce bankruptcy and we have the trustee, official receiver, someone is working for the court, collects the money and we take the house and the car and the land and the machine and the factory and the company, everything will be taken away. Then the debtor at this time cannot sell. Even it was in his name, everything was in his name up to that stage, he or she will not be able to sell anything. Because even if it was in their name, but it would be taken away and it would be sold out in an auction, في مزاد, in an auction, and the money will be taken and divided between the creditors. Even if he sells, this sale at this stage is illegal. It's not valid. If the debtor wants to sell anything, any of his property, any of his assets, this sale is not valid at this stage. Can we take anything in the UK? We still have time because we have to finish by Tuesday. Look, bankruptcy in the UK, easy. I think in the UK they have one of the best bankruptcy system. It's a comprehensive and it's unique system in which would help both sides, debtors and creditors, to work alongside each other to be able to survive, and they have reflected some of the ideas in which they would look at the economy of the country. If this economy can stay or not stay survived, and this economy can be sustained by the procedures which have been established in the state, in which the bankruptcy in Britain or in the United Kingdom is a way of dealing with the debts that the debtors cannot pay. I mean, the definition, whether this definition or what we had before, they look like the same. There's not much difference between them. Dealing with debts, debtors cannot pay. As I said, we have debt, debtors, payments. Somebody cannot pay his debts. And it's optional. We said before that we have voluntary and involuntary. It's optional. It's up to you. No one can force you. If you want to pay the money, you can pay. If you want to apply for bankruptcy, you can apply for bankruptcy. It's not something can be forced. But once we start, then it's something we have to stick to. We'll look later on. We find that you cannot escape such system. Once we are in. Bankruptcy makes a fresh start. But even this fresh start subject to some restrictions. Once you have the discharge and the freedom, and once you would like to come back to business in the future, you can come back to business. Of course you can. You can apply for permission to court and you can come back to business. But in this stage, you will not have the full freedom. You have some restrictions because you were in debt in the past. Then if you want to have a fresh start, you would have some restrictions. في قيود. And as we said before that, we have the assets shared fairly between creditors. And there's something I want you to focus on here. Look, first time bankruptcy, Haneen.
First time bankruptcy was given when they generally receive their discharge 1 year after the date of the bankruptcy order.
Yeah. Come in.
Bankruptcy has.
Oh no, it's fine. Now we have. Let's say that we have today the bankruptcy order. Decision was made. The judge has made his own decision by announcing bankruptcy order. Are you going to be free from that minute?
After you.
No. It takes 1 year, 2 years, 3 years. I mean, this charge can take time, can take 1 year. It says here, if it's the first time in your life, someone applying for bankruptcy for the first time in his life, and the amount of money was small amount of money, then you can have a discharge after 1 year. Within 1 year, you can apply for discharge. Today you have bankruptcy order, في decision, خلاص حكم الإفلاس. It takes 1 year to have a discharge إعفاء. I mean, within this time, from this time to this time, let's say from 2001, 1 year, within this 12 months, any money, any extra money you have to give it to the trustee. This it means, any extra money I have within this 12 months, the extra money, I will have to pass it to the court. After this 12 months, after we have the discharge, any extra money I make, it's mine. No one can ask me. Sometimes it takes more than 1 year. It takes 2, 3, 4, 5. It depends if it's the second time. It depends on the amount of money was in debt. I mean, it depends on the court. It depends on the court as well. Then we can have something which is called, at the end of the day, insolvency. Dealing with insolvency. Bankruptcy, in this case, bankruptcy meaning insolvency, liquidation. And I said, if we say bankruptcy, most of the time we mean liquidation. And even in a society here, people say bankruptcy meaning liquidation. Meaning insolvency, not reorganization. So insolvency has bad stigma. We will look next time at the consequences on the bankrupt, how he can feel. Stigma اللي هي وصمة شيء سيء. In the UK as well, they have an alternative to bankruptcy liquidation, which is called IVA, individual voluntary arrangement. This is an option This is an option. And this is equal to reorganization. In the United States, we call it reorganization. In the UK, we call it IVA, Individual Voluntary Arrangement. هو في يعني تسوية هو إعادة جدولة نفس الشيء. We look at the procedures. Procedures we have, they're not the same. It depends on the case. It depends on the case. It depends on the amount of money we have, allocation. It depends on what we have here. As you can see, that we have bankruptcy procedures, and they're not the same. But they can be sometimes voluntary, involuntary, and IVA. And we had before voluntary bankruptcy mean by the submitted bankruptcy petition submitted by the debtor, involuntary submitted by credit. But we state here something which is the minimum amount of money, for any debtor to ask for the bankruptcy of the debtor is at least here £750. Because I mean, even for me, this is a little amount of money. £750. If I was in debt for £750 to be applying for bankruptcy for such amount of money is nothing. But it says that you can apply. Any creditor owed money, له عند المدين, owed money £750 at least. Or we can have another option which is called IVA, Individual Voluntary Arrangement, which is equal to reorganization. Now, once we have bankruptcy procedures have started, we cannot say no. As a debtor, I would not here refuse. I would have fully to cooperate. Debtor has to cooperate with the procedures fully. Otherwise, if the debtor does not cooperate, it means he's not sincere, he's not honest. And if he's not sincere or honest, then the claim is true. Then the claim is against him. Then he might not be even relieved. He might not have discharge. So once we have the procedures have begun, then we have to have the debtor cooperating fully. If the court asks him to attend, you have to attend. If you have to bring bank statement, you have to give the bank statement. If you have to submit any document, you have to. You cannot say no.
Proceedings, options.
Procedures start with the submitting of the bankruptcy petition. The procedures starting with the bankruptcy petition. First step, bankruptcy petition. Then we said last time that we have the trustee. The trustee, he would collect the money and the assets. He can sell. He can collect everything available about the financial aspect of the debtor and his life. And from then we can start until we have the final decision of bankruptcy order, until we get the discharge. These are procedures. We can avoid this. We can avoid it by having settlement. We can reach a settlement, اللي هو تسوية. This settlement can be between debtor and creditors. Once we reach it, that will be a solution, and we can avoid insolvency. Take this last slide. There are some types of fees. Some types of fees have to be paid. These fees, of course, once you apply for bankruptcy petition, if you would like to apply for anything, if you submit any petition to the court, even if it's not bankruptcy, and a file, you have to submit the fees with them. In Palestine, the fees should be 1% of the amount of money. How much is? In the UK, it says the court fees is £120, which is nothing. It's a little amount of money. Sometimes this £120 here, you can be discharged from them. Why? Because if you have no income, and if this debtor was on income support, he was dependent on the state. He does not get money. People in the UK who does not have money, who do not work, they can have something which is called income support, which is welfare payment, which is paid from the state to them. In this case, if you have no money, of course, you will be released from the amount of money which has to be paid as court fees. And there's something called deposit, which is 250. This is not so important for you anyway. Once you are in the UK, you should know how much you should pay for the court fees. I mean, at least you have to know. And even here, sometimes you have to be a statement affair for the swear of a statement of affairs. حلف اليمين. There's some money have to be paid with the petition. If two married couple applying for bankruptcy, each one has to pay the fees separately. If we have a partnership, if we don't have partnership as we had before, if we have a partnership, then each one has to pay the fees. Even though if it's one partnership, but each partner will have to pay his own fees unless they have joint petition. Once they have a joint petition, it's only one fees. Otherwise, each one of them have to be a separate fees. Thank you for your time.
Alternative dispute resolution arbitration. Arbitration is a form of alternative dispute resolution, and it's a legal technique that used to resolve the dispute outside the courts, and it refers the disputes for one or more person arbitrators. It's a settlement technique in which a third party reviews the case and imposes decisions that is legally binding for both sides. Forms of arbitration. Mediations is that a form of settlement negotiation facilitated by a neutral third party. Non-binding resolution by binding resolution applied by who have a previous experience, voluntary or mandatory. Advantages and disadvantages. Advantages of arbitration is often faster than litigations in court, and it can be cheaper and more flexible for business, and it's generally easier for enforce than court judgments. Disadvantages. If the arbitration is mandatory and binding, the parties waive their rights to assist the court and have a judge or decide the case. In some arbitration agreements, the parties are required to pay for arbitration, which adds an additional layer of legal costs that can be prohibitive. Arbitration agreements. In theory, arbitration is a consensual process. Parties can't be forced to arbitrate a dispute unless he or she agree to do so. In practice, however, many fine print arbitration agreements are inserted in situations in which employee and consumers have no bargaining power. Type of agreements. Agreements which provide that if a dispute should arise, it will be resolved by arbitration. This will generally be normal contract. Agreements which are signed after dispute has arisen, agreeing that the dispute should be resolved by arbitration.
Now I will continue and talk about the applicable law. When we talk about the applicable law, the law is govern the arbitrations agreements, and the law govern the arbitral and its proceeding, and the law government the regulations and enforcement of the award. The arbitrations agreement, which is the part of the main contract that is referred to as a container contract, and it's governed by the law which govern the main contract. And the fact that arbitrations agreement is automated the main agreement. The seed of the arbitrations, most legal system recognize the concept of a seed of the arbitration, which is geographical and legal jurisdictions to which the arbitrations is died, and the seed will normally determine the procedure rules which the arbitrations follow. and the law applicable to the procedure. The essential matters of a procedure are determined by the procedure law of the seat of the arbitration and may be decided by the resource to courts. The practice normally influence this through their choice of the seat of arbitrations or directly through choice of procedure law. The arbitration's power determined procedure matters normally include the mode of submitting and time and place of any translations and appointment of experts. And we talked about the arbitral tribunal. The term it's used to denote the arbitrators sitting to determine the dispute. The compensations of the arbitral can vary enormously with either a sole arbitrators with or without assurance and various other combination. In most jurisdictions, an arbitrator enjoy immunity from liability for anything done or omitted. Law applicable to substance. Parties in a commercial dispute will often choose the law applicable to the substance of their dispute, and in fact they are more likely to choose substance.
Okay, I will talk about for kids entertainment TV. I think everyone knows about it. It's for animation, for producing and licensing animes on TV. And it's filed for bankruptcy in this year, in 2012. It's filed for Chapter 11 bankruptcy. It's about the company. For Kids Entertainment Company, known as For Kids, is an American films and television production company. In bankruptcy since 2011. This year, it is known for English dubbing Japanese animes, and specializing in the acquisition of licensing production of the children entertainment and around the United States, and it's around the world, the whole world. For Kids Entertainment has its world headquarters in the 6th Avenue in the New York City. Its subsidiary For Kids Productions has its headquarters in the separate building in Manhattan. The New York Stock Exchange delisted For Kids NYSE KDA on June 1st, 2010. On April 6, 2011, it filed for Chapter 11 bankruptcy. Protection. Following the lawsuit concerning the UGO franchise, it's an animation that we have, every one of us have watched it since we were kids. The UGO. The list of For Kids licenses and production. For Kids Entertainment licenses wide variety of media products ranging from the video games to television programs to the toy lines featuring the Royal Air Force. For Kids focuses on licensing the content of children and the preteen market. It's for boys, for both boys and girls. Many of its licenses come from the depths of the dubs of Japanese anime, like including fighting Furons and Shaman King, while others are Western in the US of properties like Chaotic or Back to the Future, the animated series. Most programs are either licenses or produced or in the company itself. The CW For Kids. The CW is a combination of CBS and the Warner Brothers company. The Warner Brothers and the CBS announced that For Kids, that the kids WB Warner Bros. Programming block, and it can't produce anymore on the television and houses and cable lines due to factor of competition and many factors. They faced difficulties in their work. The rights for 5 hours Saturday, they were producing their programs 5 hours a day, Saturday in the morning for kids, and the right of the 5 hours, these 5 hours, 4 kids purchased it, and they bought it, and they began program, and the time with their own program. They mixed with the original CBS and the Warner Bros. They become CW for kids. The CBS and the Warner Bros. And the 4 kids, the 3 of them are mixed together to make the 5 hours become 9 hours. The original 4 hours of the 4 kids on TV, and the extra 5 hours of the CBS CW company, they become 9 hours. They're producing the TV on TV. The 4 kids and the CW, they changed their name to become Tunzai. They started in August 14 to 2010. They featuring like. They feature the magical Doremi, and everyone have a robot for robots for everyone, Dinosaur King, and Yu-Gi-Oh 5Ds, Yu-Gi-Oh Zixal, and the Dragon Ball. And those are the animation that the company produces, like Chayotek, Pokemon, Viva Pinata. Everyone knows it, especially Viva Pinata and Pokemon. Yu-Gi-Oh lawsuit and bankruptcy. The cause of the bankruptcy of this company is the Yu-Gi-Oh animation, and which is purchased it. The company purchased the Yu-Gi-Oh without a license, without paying the money for the original company, which is Tokyo TV Tokyo and Nihon System. They are sued the 4 Kids Entertainment, allying that the company entered into illegal agreement with other companies, including Funimation Entertainment and Majisco Entertainment. These are 3 companies purchased it with no license. The Yu-Gi-Oh animation. The TV Tokyo claimed that those agreements allowed 4 kids to collect royalties without paying the portion of these royalties to TV Tokyo, which violates their original agreement. The companies are seeking almost $5 million in their underpayments, the wrongful deductions, and the unmet obligations. A part of the suit, the companies terminated the Yu-Gi-Oh license from the 4 Kids. It doesn't produce it anymore. It's last slide. The 4 Kids has filed for Chapter 11 bankruptcy protection as of April 6, 2011. 4 Kids requested that the court suspend licensor. The company licensor is Asatsu DK. He's a Japanese licensor. Attempts to exercise control of the Yu-Gi-Oh franchise. Is the legal franchise to make it legal in the United States, particularly in terms of the selling the rights in the latest anime series Yu-Gi-Oh Zixal, this latest anime, and he's continuing the legal franchise of it, which was due to the pitch at the licensing international expo and on June 14. The court issued an order. The judge called Shelly Chapman issued court order on TV Tokyo and as for an automatic stay in the U.S. Yu-Gi-Oh license, and the state there is two phases. In the first phase is whether the contract term is nation was valid. The second, the company should pay everything has owed to its debtor, the TV Tokyo, the original company, and the first phase is started in this year in August.
Okay, Bank of Palestine. Bank of Palestine is the first and largest national bank. Was founded in 1960 and commenced its operations on February 1961 to give small loans to projects, businesses, and limited short-term personal loans. Bank of Palestine Public Limited Company is a financial institution operating through the Palestinian Authority. Bank of Palestine is the most relevant in Palestine through the banking network. Consists of 45 branches and sub-branches extended from Jenin in the north to Rafah in the south. Bank of Palestine has outstanding management team and highly qualified professional working in the bank. Currently has over 1,000 employees. It offers many distinguished banking services that meet customer needs and expectation, includes services and personnel and companies. It provides both personal and corporate banking services, including current and saving accounts, loans, credit cards, certified of guarantees, letters of credit, letters of guarantees, financing commercial contracts, and bills collection. Bank of Palestine celebrated this year's Golden Jubilee on the occasion of the passage of 50 years of its foundation under the slogan 50 years of building. The bank was listed in the Palestinian Exchange in 2005 as a public shareholding at the end of 2006. Bank of Palestine founded the brokerage firm for securities investment, Al-Wasata, which has 3 branches in Gaza City, Ramallah, and Khan Yunis. During short period, the company became the first company in terms of increasing the number of accounts opened, and the third in terms of trading volume among the 10 brokerage firms located in Palestine. Bank of Palestine has $120 million paid up capital after distributing $20 million stock dividends to shareholders in May 2011. The bank has the second highest market capitalization in Palestine Stock Exchange, following Baltil, and accounted for 13.88% of the total market capitalization of Palestine Stock Exchange in 2010, according to statistics by Stock Exchange. Stock price. Palestine Stock Exchange data shows that Bank of Palestine started trading on November 2005. The highest price was $6.75 in 2005, which accompanied an increase in overall prices on Palestine Stock Exchange Index. The share recorded its lowest level in 2006, having reached $2.5. It was most volatile in 2007, with the difference between the annual low and high prices reaching $3.54. And nowadays, I see at Al-Wasata webpage that the stock price of Bank of Palestine is decreased. I asked someone who worked in the bank. He told me that the economic situation is affected on the bank, and the bank is imposed on it tax about $10 million. Thanks for listening.